Thank you very much, Béatrice. And I think your last comment leads us also to say we should not talk about CRISPR, we should talk about genome editing technology because they're a wide variety. Luis Monteliu.
The more I listen to these topics, the more sad I become. Because in the academic arena, we are only limited by our imagination, and whereas the conversion of these very nice applications that we are trying to put forward from the academia into reality, taken up by industry, they require patents. They require protecting their investments in order to fulfill their expectations and their benefits. This is difficult to understand for us. You can imagine how difficult this is to understand from the public opinion, from the public side. I think we need to do something about this, because here we have a coalition of two different forces. We have one of the most wonderful tools that we have ever come across for modifying genomes. We can virtually do whatever we want at the level of the laboratory. That is very complicated to convert this into applications. And applications, they cover from the industrial applications to developing therapeutical drugs that are being taken up by companies and brought into hospitals. So we need to be clear in this society about this, and we need to transfer to this society that there is also some ethical responsibility by all these different companies that are engaged into this dispute, because basically, because of this dispute, we are preventing from the transmission of these benefits from the laboratory to the society.
Yeah, but at least the MIT Broad made it clear on their website that the intent is to favor the large diffusion of the technology. And that's the reason why they give free access to the technology to the public research and non-profit community. The meaning that you can do research in the lab. Once you find something, I guess, that you would try also to file a patent application, and it's a spin-off company would be created, that the issue of getting a license would arise. And we can imagine that from now until the time you find concrete application, the patent situation would have been clear, or that at least the patent pool would have been successfully launched. The patent pool is something which is more and more commonly launched in the electronic field, because all the phone technologies, there are norms, and the patent owner that have protection on the norm would otherwise block access to the technology to all the competitors. So this system was initially developed in that field of technology, and I can imagine that it would also it could succeed also for the CRISPR technology, because it is to ensure a broad access to the technology to multiple players in the market, and with a reasonable fee, because the more players there are in the market, the more the patent owner would get return on their investment due to the multiplicity of the license, even if the royalties are low.
Yes, hello, my name is Julien Potet. I work at MSF, Médecins Sans Frontières, at the Access Campaign. MSF is interested into CRISPR for different applications for infectious disease diagnostic platforms, very versatile platforms like Sherlock that have been, for example, developed by the MIT and the Broad Institute, and we also work on possible gene drives for control of malaria and control of mosquitoes. I had a question about the patents. There was a proposal 2 years ago by somebody from the MIT named Kevin Esvelt, who has developed some patents on gene drives, and he suggested that academia, in order to have access to continue follow-on research, he suggested that academia, there would be a requirement for academics to publish everything that they wanted to do with CRISPR and gene drives, before being allowed to use this technology. Currently, academia can use CRISPR without any patents, of course, but he suggested to use the patent as a way to be extremely transparent. So there would be a requirement for any academic team to be extremely transparent about their projects if they want to use a CRISPR-associated tool to pursue their project. So it would be a complete different approach, because academia can do the projects with that kind of requirement in terms of IP. So I wanted to know you as an IP expert, whether you think it's a possible thing to do, and whether it would be an effective solution to make sure that all teams put on the table what research they conduct.
The limitation of regarding gene drive, for instance, has been forced onto Monsanto, because the license they got was forbid the implementation of the technology with this aim. So obviously, as long as they own the patent is a right to prohibit others from implementing the invention without your authorization. So you may authorize without condition, but you may also authorize with condition. And typically what you describe is something which can be implemented in reality. Yeah.
Mr. Sinan Brahim from CNRS Innovation. We are managing the IP for CNRS Research Center in France, and we are managing its transfer. I have just let's say two very quick comments on your very interesting presentation and regarding the discussions. The first one is, as we said, I think in the subject of ethical issues, the fact that in academia the access is free to some technologies, there is, let's say, an importance to give to the ethical issues, in fact, also for researchers, in order to limit maybe the risk and to establish some the best practice and what they can do or not to do. The second one is regarding the licensing. I think regarding the licensing, the fact that we limit by the patent the access to technology, it's something that is, let's say, traditional in the research, but I think could be adopted. One solution regarding the ethical and especially the accessibility to technologies, maybe we can have a specific rules in terms of licensing towards the licensees of technologies, in order to limit the
Sorry to interrupt. We are very late.
Allow the accessibility to technologies and limit, for example, the price to accessibility. Yeah, thank you.